My son Doug was catapulted into the air and landed on a metal grate alongside of a cold bridge to die alone.
Son's body was left in the road in 3 pieces. How many pieces did he have to be in to get justice?
Joseph Eaton confessed to the deaths of his parents, Cynthia and David Eaton, and their friends, Robert and Patricia Eager. The courtroom was filled with emotional testimonies from family and friends, mourning the devastating loss. The incident began when Eaton took the lives of the 4 victims at a home in Bodwin. Following the crime, he fled the scene and later opened fire on vehicles along Interstate 295, injuring 3 people. During the sentencing hearing, Lisa Shea, who discovered the victims, shared the lasting trauma of that moment.
It will haunt me forever. The blood, the glass, the guns.
Family members expressed their grief, describing the deep void left in their lives.
I wonder how they'd respond to you if they were still here. I actually know. They'd greet you with open arms, like always, show you love and compassion. Well, guess what? That ain't happening. They're dead. All 4 of them, dead, gone. Never to be seen, never to be heard, nor hugged, nor loved, ever again.
Eaton, visibly emotional, addressed the court, admitting guilt and stating, prosecutors pushed for the harshest punishment, emphasizing the irreversible harm caused.
4 counts of intentional or knowing murder, count of aggravated cruelty to animals.
Eaton pleaded guilty to multiple charges, including 4 counts of intentional or knowing murder, 1 count of aggravated cruelty to animals, 3 counts of attempted murder, 1 count of aggravated assault, and 1 count of illegal possession of a firearm by a felon. The judge sentenced him to life in prison for each murder, served concurrently, along with 30 years for each attempted murder charge. Neither Eaton nor his attorneys requested leniency. Rick DeBate was convicted of murdering his wife, Connie, at their home in Ellington. Prosecutors argued that he carefully staged the crime scene, fabricating a story about an intruder to cover up his actions. A jury found him guilty of murder, tampering with evidence, and making false statements. Connie's family delivered emotional statements about their loss.
The first thing she said on the phone was, "Mom, I love you. You're my best friend." And I didn't know what's going on. I said, "I love you too. I just want to let you know, Rick is a mess today." And I just wish I had said, "Well, if he's such a mess, why don't you come to my house? We'll have breakfast."
Her mother recalled their final conversation, in which Connie mentioned that DeBate was acting unusually. Looking back, she wished she had urged her daughter to come over instead of returning home. The pain of losing Connie was evident as her loved ones described the devastation her death caused. Despite overwhelming evidence, DeBate continued to claim innocence, insisting he was the victim of false accusations. He maintained his story, vowing to appeal the conviction.
He is completely steadfast in his innocence and dedicated to proving his innocence. Today was the close of just the first chapter of the litigation in this case.
While DeBate's family portrayed him as a good man, Connie's relatives described him as deceitful and remorseless.
He's a liar. He's a thief. He's a murderer. He stole our lives. He stole our best friend. He robbed our children of their best friends.
Judge Corinne L. Klatt sentenced him to 65 years in prison, calling his actions brutal, calculated, and incomprehensible. As the courtroom proceedings ended, emotions ran high. For Connie's loved ones, justice had been served, but the loss of their daughter, sister, and friend could never be undone. In 2017, 35-year-old fitness instructor Nada Houranieh was found deceased outside her Farmington Hills, Michigan home. Authorities determined she had been killed before being pushed from a second-story window, with the scene staged to appear as an accidental fall.
Started noticing that the positioning of her body was not what you would expect from someone falling out of the window.
At the time, Nada was in the middle of a difficult divorce from her husband, Basil Al-Tantawi. Their marriage had become strained after an incident in which Basil was ordered out of the house following allegations of domestic conflict. She filed for divorce soon after. Seeking a fresh start, their son, Mohammed Al-Tantawi, took his father's side during the legal battle. Prosecutors later argued that he deeply resented his mother for ending the marriage. This tension escalated into tragedy, leading to his conviction for first-degree premeditated murder. During the trial, the medical examiner testified that Nada's passing was caused by a lack of oxygen, which occurred before she was found outside her home.
In your opinion, doctor, this happened before or after the body falling out of the window?
My observation indicates that it happened before.
A jury deliberated for only 2 hours before reaching a guilty verdict.
So it is the sentence of this court with respect to the one count of homicide, murder in the first degree, premeditated, that you be sentenced to 35 years to 60 years with the Michigan Department of Corrections. You have 1,858 days of jail credit. You are to pay DNA costs of $60, state costs of $68. The Crime Victims' Rights Fund $130, and you're to comply with DNA testing. And as I indicated previously, you're to have no contact or association with your mother, Nada Haranya's family. And when I say family, I mean her immediate family, her mother, father, sisters, and brother.
During sentencing, the judge handed down a prison term of 35 to 60 years, along with additional legal and financial penalties. As part of the ruling, Al-Tantawi was prohibited from having any contact with his mother's immediate family, including her parents and siblings. As the sentence was announced, a family member directed a final remark at him. "Have fun rotting in prison, murderer."
I have one quick question, if you would entertain me. As you just sentenced me, with the posture of everything as it is right now, notwithstanding the appeal, I very well would be in prison for at least 35 years. I've been locked up for 5 years, and I haven't had the opportunity to see my sister, Sidra or Nakada, at all in the last 5 years. She was 13 years old, she's 17, soon to turn 18 in a month. But my father, I haven't seen him in over 2 years because of COVID in the jail. I asked, they just give me a few minutes, 1 or 2 minutes to interact with
I'm afraid I can't do that, sir.
Okay.
That's not allowed.
Okay.
Thank you.
Before being taken away, Al-Tantawi attempted to speak, requesting a chance to see his younger sister and father, whom he had not seen in years. The judge denied his request, signaling the end of the proceedings. Jessica Trefethen was charged in connection with the tragic passing of her son, Maddox Williams. Authorities responded after Maddox was brought to Waldo County General Hospital, where he was later pronounced deceased. During the investigation, Trefethen stated that Maddox had been accidentally injured while playing. However, medical experts determined that his condition was more serious than what would typically result from minor accidents.
Depraved indifference murder is defined by statute as involving conduct that is a disregard for the value of human life.
Prosecutors charged Trefethen with depraved indifference murder, a legal term used when someone's actions show a disregard for safety and well-being. Outside the courthouse, messages reading "Justice for Maddox" reflected the public's emotional response.
The family obviously has suffered a loss. They will continue to feel the effects of that loss for a period of time.
Following a trial, a jury found Trefethen guilty. In December, she was sentenced to 47 years in prison after prosecutors presented substantial evidence. She later appealed the ruling, but the Maine Supreme Judicial Court upheld both her conviction and sentence, affirming the decision. Trefethen remains incarcerated, serving her sentence for the loss of Maddox Williams. On New Year's Day, police responded to a call on Gareth Circle in Stockton, California, where they found 47-year-old LaToya Sivens with a gunshot wound. She was rushed to the hospital, but didn't survive.
On January 1st of this year, Stockton Police Department and the City of Stockton had their first homicide, whereby the defendant, who was the son of the victim, shot inside of a vehicle, resulting in the of his mother.
Authorities quickly identified her son, 20-year-old Jaquan Williams, as the suspect. He was located within hours and taken into custody for questioning. Prosecutors later charged him with voluntary manslaughter, suggesting the incident was not premeditated but occurred in the heat of the moment.
The case is still pending investigation. There are interviews to be completed. At this point, the defendant is charged with voluntary manslaughter.
In court, Williams appeared emotional as he faced the judge for the first time. Family members present described the situation as a tragic accident, emphasizing that Williams had a close and loving relationship with his mother. They also mentioned that he struggled with mental health challenges. As the case continues, investigators are conducting further interviews to gather more information. A hearing has been scheduled to review bail and proceed with legal matters. Meanwhile, the community mourns LaToya Sivens, with friends and family leaving flowers, candles, and messages at the scene in her memory. Peterson Drew Matheson was driving a Ford F-150 when a road rage incident on SR 73 took a tragic turn. According to authorities, his truck swerved into oncoming traffic and collided with another vehicle, resulting in the loss of Rodney Salm and Michaela Himmelberger. In court, family and friends gathered to remember the victims and express the devastating impact of the crash. A relative emphasized that this was not an accident but the result of reckless decisions made over several miles.
This was not a poor soul suffering a medical event, or an overstressed parent distracted by a screaming child in the back seat, or an inexperienced driver making a terrible mistake. All the driving choices made that day were made on purpose, and this road rampage went for nearly 5 miles.
Salm's brother, Peter, shared his grief, saying,
"He was my brother. He was loved by so many. We need to send a message out to other people who do this stuff. They need to know it's not right. It's not going to be tolerated."
Deputy County Attorney McKay Lewis used the case as a warning about the dangers of reckless driving.
You really just need to think and calm down on the road and think about what you're going to do before you do it, because it could lead to a situation like this where tragically lives were lost and, someone's going to prison.
After hearing the emotional testimonies, the judge sentenced Matheson to up to 10 years in prison, with 2 consecutive terms of up to 5 years each. Since he had already served 19 months, the Utah Board of Pardons and Parole will ultimately determine his release. Recent investigations revealed that another driver, Michael Allen Landon, played a role in the events leading up to the crash. Prosecutors charged Landon with 2 counts of negligent homicide and 1 count of reckless driving, alleging that he accelerated to block Matheson from passing on the right shoulder. This confrontation led to multiple contacts between their vehicles, ultimately resulting in Matheson's truck veering into oncoming traffic. Authorities stressed that both drivers contributed to the tragedy, underscoring the dangers of aggressive driving. A tragic conflict between students at New Rochelle High School led to a heartbreaking loss that shook the community. The incident began as an argument between 2 groups off campus during a school day. In the midst of the dispute, tensions escalated, and Valerie Schwab, a student, was injured in an altercation involving Zeina Brown. Authorities later revealed that Brown had faced significant hardships, including homelessness, but the court emphasized that personal struggles did not excuse her actions. The case deeply impacted the school district, leading to growing concerns about student safety. During the sentencing, the courtroom was filled with emotion as Schwab's sister spoke about the pain of losing a loved one so suddenly.
Zeina Brown, I hope you figure out a way to bear your burden, because ours is heavier each day.
She expressed the family's sorrow, describing how their lives had been forever changed.
Your sudden, senseless act of violence stole her life young, and none of us will ever understand why. We never thought we would be thinking about Valerie as a memory, but today we do.
Judge Barry Warhit acknowledged the devastating impact of the case, calling the events leading to Schwab's passing both tragic and irreversible. Honoring the plea agreement, he sentenced Brown to 17 years in prison. After the proceedings, Brown remained silent, showing no visible emotion, while her attorney and family left without comment. The incident was part of a series of safety concerns within the school community, eventually leading to leadership changes within the district. Rachel Foster, 24, and her boyfriend, Giovannis Rocchi, were stranded on the Palmetto Expressway after their car broke down. As they waited for help, a vehicle driven by Leonardo Morciego struck them, killing Foster and leaving Rocchi seriously injured. Authorities later confirmed that Morciego was driving under the influence, with a blood alcohol level exceeding the legal limit.
I just think the person who killed my daughter on Father's Day, June 19th, 2016, needs to pay for what he did.
In court, Foster's mother spoke about the devastating loss of her daughter, describing her as a loving mother, aspiring teacher, and gifted dancer.
Su condena, por muy larga que le parezca, es solamente pasajera. La ausencia de nuestra Rachel Colleen es para siempre.
Addressing Morciego directly, she expressed the deep pain her family endured. Overcome with emotion, Morciego apologized through tears, saying he kept the family in his prayers.
To apologize to all of the family. I always have them in my prayers.
The judge sentenced him to 5 years in prison, followed by 2 years of house arrest and 4 years of probation. As he was taken into custody, his family left the courtroom in silence. The Foster family, while grateful for justice, knew that no sentence could undo their loss. Tragedy struck again when Rachel's daughter, Savannah, passed away months later. Authorities in Texas charged the girl's father in connection with her death. The family took solace in knowing that mother and daughter were now reunited in peace. Douglas Kozar and Kate Collier, both 23, were walking along the Harbor Island Bridge when a speeding car lost control and crashed into them. The driver, Matthew Moy, a Riverview dentist, had just left a Halloween party and was later found to be under the influence, driving at 89 miles per hour with a blood alcohol level above the legal limit. The impact proved fatal, leaving 2 families devastated.
I'd like to read a letter that I wrote to Doug. Take a deep breath. The day before his funeral. I can't begin to put into words the pain and anguish that I'm feeling right now. My heart's broken and I know it will never heal.
In the courtroom, Kozar's father read a heartfelt letter he had written to his son before his funeral, expressing the unbearable pain of losing him.
The morning I received a phone call about the crash changed my life forever. The void in my heart will never be filled. Please look down on us every day and give us a sign that you're happy and okay. I'll never stop loving you, Dad.
With grief turning to anger, he turned to Moy, condemning his reckless actions and calling him selfish for disregarding the law.
I have no forgiveness for you, and I have no sympathy. I think you're an arrogant, narcissistic, despicable individual who believes that the law pertains to everyone else except himself.
Collier's parents also spoke, sharing how their daughter's absence had left a permanent void in their lives.
My son Doug was catapulted into the air and landed on a metal grate alongside of a cold bridge to die alone.
The judge sentenced Moy to 12 years in prison, followed by 10 years of probation. His driver's license was revoked permanently. Throughout the proceedings, he remained silent, offering no words before being taken into custody. In August 2013, 41-year-old bicyclist Tim Van Orden was struck and killed by a vehicle in Boca Raton. The driver, 24-year-old Drew Blazure, had a blood alcohol level of 0.210%, nearly 3 times the legal limit. Following the crash, Blazure fled the scene, which resulted in additional charges against him. Years later, in 2017, Blazure was sentenced to 364 days in the Palm Beach County Jail for vehicular homicide. His sentence fell far below the mandatory 4-year minimum typically imposed for DUI manslaughter in Florida. The decision left Van Orden's family devastated, believing that justice had not been served. During the sentencing, prosecutors justified the plea deal by citing conflicting witness statements that cast doubt on whether Blazure was the driver. The victim's family strongly opposed this reasoning, arguing that the state had failed to build a strong case. They also alleged that they were pressured into accepting the plea agreement through intimidation tactics. Adding to their frustration, the family claimed they were informed of the plea deal only after it had already been finalized.
There was never a plea conference. I was told after the plea was already made. And maybe I would have agreed to it, but that left me out. I mean, for crying out loud, my son's
He was left in the road in 3 pieces. How many pieces did he have to be in to get justice?
The state maintained that no clear eyewitnesses had come forward, making the plea deal the most viable legal option. A spokesperson for the state attorney's office insisted that the family had been included in the plea negotiations, but declined to comment further. Following his release from jail after serving 364 days, Blazer was to serve 2 years of house arrest, followed by 4 years of probation. The state maintained its stance on the sentence that it was justified given the circumstances. On a snowy night in early April 2024, a long-standing tension between neighbors in Rochester, New Hampshire, turned deadly. Jason Levesque, having just finished over 38 hours of plowing during a severe snowstorm, returned home and began clearing his own driveway around 10 p.m. As he worked, his neighbor, Kyle Violette, approached him and a confrontation followed. According to Levesque, Violette angrily threatened to kill him and his family if any snow ended up on his property. Feeling threatened, Levesque retrieved a firearm and shot Violette. The situation quickly drew police attention. Officer Tiana Adams from the Rochester Police Department was called to the area of 41 and 43 Summer Street. Upon arriving, she was directed by her sergeant to canvass the neighborhood. At a nearby residence, 38 Summer Street, she observed a Ring camera and spoke to the homeowner. The resident allowed Officer Adams to review the footage and later sent it to her electronically. The video, which captured the sounds of an argument followed by shots, became a key piece of evidence in the investigation.
Yes, it does.
And what address was that?
I responded to 41, and per my report says I went to 38.
When you went to 38 Summer Street, can you tell us a little bit about what you did once you got there?
Yes, so upon approach, I observed a Ring camera. I knocked on the door and I spoke with the resident. My sergeant started speaking with her about the incident that had occurred, asked her a few questions if she had heard anything like that. And then we asked to see her Ring camera footage.
Did you personally view that footage with
Yes.
the camera?
Yes, I did.
If I were to show you that footage, would you be able to identify it?
Yes.
Okay. Your Honor, I believe we will need to set up for another view. Thank you. Officer, so Bill, bear with us for a moment. Counsel, this is exhibit 2. Yes.
We may shift it.
Yeah.
This is actually just audio. Oh, yeah. We're just moving because of the instruction, Judge, that's all. Yes.
Your Honor, with permission, I would step down.
Yes.
Sir, if you would just briefly step down from the witness stand. Thank you.
Counsel, this is a full exhibit?
Yes, Your Honor.
Thank you.
Officer Adams, I'm showing you right now, it is a essentially still shot at the very beginning of a video. Does this look familiar to you? How do you recognize this video?
I recognize it as the Ring camera footage from the residence.
Now, I just want to be clear, this Ring camera footage, does this show you the specific address of 41 or 43 Summer Street?
It's next door.
What, based on your review of this, were you able to determine in reviewing this video?
I could hear the argument and the shots that were fired.
Is this how you recall seeing the video when you viewed it? after you viewed this footage from the resident of 38 Summer Street, what did you then do?
I asked her if she was willing to send it to me via text or email, and she agreed to do so.
She did do so.
Detectives also spoke with witnesses and collected physical evidence from the scene. The footage provided by the neighbor's Ring camera showed that Violette appeared to be walking away at the moment Levesque fired the first shot, raising questions about the claim of self-defense. During the trial, Jason Levesque took the stand in his own defense. He stated that he feared for his life and the safety of his family after Violette allegedly made direct threats. However, the prosecution used the video evidence to challenge that narrative, arguing that Violette posed no immediate danger when the shooting occurred.
Thank you, sir. As to the first charge ID 228154C, which charges Jason Levesque with the offense of attempted murder, do you find the defendant guilty or not guilty?
Not guilty.
And the verdict is not guilty. All members of the jury, so say you all?
Yes. Yes.
Attorney Barth, Attorney Dylann, would you like the jury polls?
No.
And as to the second charge ID 22285155C, which charges Jason Levesque with the offense of first-degree assault, do you find the defendant guilty or not guilty?
Guilty.
And the verdict is guilty on first-degree assault. So say you all members of the jury.
Yes.
Attorney Sisti.
After several days of testimony, the jury reached its decision. Levesque was acquitted of attempted murder, but found guilty of first-degree assault. This charge carries a possible prison sentence of up to 15 years. His sentencing will take place at a later date. Paul Yantis, a 20-year-old from Idaho Falls, found himself at the center of multiple criminal and civil cases after a series of poor financial decisions unraveled in 2023. At the time, Yantis was operating his own business, Yantis Landscaping, and appeared to be a driven young contractor. However, things took a wrong turn when he began making high-value purchases using checks from an account with no available funds. In late March of that year, Yantis bought a 2011 Ford F-150 from a private seller in Ammon for $22,000. The very next day, he purchased a Polaris side-by-side ATV for over $34,000 from Action Motorsports in Idaho Falls. Just days later, he picked up a four-wheeler from Blackfoot Motorsports and tried to trade it for snowmobiles and a trailer. Then, on April 1st, he returned to Action Motorsports to buy a Polaris R ZR TV worth more than $44,000. In each case, Yantis used checks that were later found to be worthless due to insufficient funds. These incidents led to felony charges in Bingham and Bonneville counties, including burglary, grand theft, and writing bad checks. While these criminal matters were unfolding, complaints also emerged regarding his landscaping business. Several clients, including a former sheriff's deputy, accused him of accepting large deposits for projects he never finished, or in some cases, never started. Some customers reported property damage, minimal work, and communication that abruptly ended. These situations led to small claims lawsuits and added to the growing list of allegations against him. By April 2024, Yantis entered a plea deal, admitting guilt to reduced charges of issuing bad checks. As part of the agreement, the more serious charges were dismissed. He was sentenced to 2.5 years of felony probation in Bingham County. However, after missing multiple court appearances, warrants were issued for his arrest. He was later taken into custody and transferred to Bonneville County, where the court prepared to move forward with additional sentencing. During the hearing, Yantis' defense team argued that he had not acted with criminal intent.
Thank you, Your Honor. This case revolves around Mr. Yantis. He owned a construction company of his own. He had taken on some pretty big contracts, was being paid on those contracts, and then for whatever reason he had to pull out of one of the contracts, one of the large paying contracts. Prior to doing that, he had purchased these vehicles thinking that the money was going to be in there either the next day or a couple days from when he did it. The money didn't come through. He ended up not taking on those contracts. I think there's a mental health component here that needs to be addressed with Mr. Yantis. I don't think it's just, a misunderstanding of, hey, I thought I was going to write a check and I didn't. I think that this is possibly some bipolar type type behavior where he becomes manic, and he went out and bought several vehicles and a side-by-side four-wheeler type vehicle, and then just couldn't pay for them, and so he had to take everything back. These people were kind of upset because they had sold these vehicles and then had to get them back, and so I don't think that Mr. Yantis was necessarily doing this maliciously or trying to escape on having to pay for these vehicles. I think that it was just, I think that there's something that can be addressed while he's on probation as far as mental health goes. I think he has some mental health issues that need to be addressed, and learn some coping skills on how to do that. I certainly think all this can be done on probation. I realize that the state probably would not have made this agreement had they known all the other issues that Mr. Yantis had in other counties and in other, even in this county. But it is what it is, and this is very rare that this type of situation comes up. And so we would just ask the court to follow through with the plea agreement, with the recommendations of the parties, where he's put on probation. Hopefully we can get him some mental health help, because I think that's kind of the root of the problem. He does need to get it back out and get out and start working. He's very skilled. He's a good construction contractor. He's got a lot of jobs out there that he can do. He does, as he said, have a baby on the way. He's told me that a number of times, and that was one of his driving forces of getting out and getting back to work, was that he has people to provide for, and that's very admirable. I think that Mr. Yantis is trying to be a fine, upstanding citizen, and I think that sometimes, his mental health gets in the way, and situations kind of turn upside down. Things that he wasn't expecting to happen, and it led him into this particular situation. He has a very low LSI. His LSI is a 7, which is extremely low. According to, and we're all going off of the Bingham County PSI, and so, which was done right around this time period that this case happened. So, but I think he's amenable to probation. I think that if the court puts him on probation, he'll do well. And I think that the probation officer will be able to at least look into the mental health issues that may be present there. That'll be somebody who can delve a little bit deeper into his possible issues and help him get back on the right track. That's what they're there for. That's what they do. And they do a great job at it. And so I think that at the end of the day, Mr. Yantis is going to be a success story for us. As I said earlier, he's a very hard worker. He's a very skilled contractor, and I think that he can get back on his feet and get back on the right path. I think this will be a stumbling block for Mr. Yantis. So.
The defense claimed he believed payments from a construction contract were about to be deposited, and he had even informed one seller to wait before cashing the check. When the expected funds didn't come through, he was unable to cover the purchases. His attorneys suggested that his actions were driven more by emotional instability and possibly untreated bipolar disorder than by a plan to deceive. His low-risk LSI, level of service inventory score, recorded during a pre-sentencing evaluation in Bingham County, was also cited to support their argument for leniency. Yantis himself briefly addressed the court.
There was no malicious intent in the crimes committed in this case. I understand that, it kind of took a different route, but like you said, there was no destructive intent. It was, like you said, the contracts were coming through. One of them was supposed to pay out the next day. I told the power sports company that I bought the ATV from that the check needed to be, they need to wait a couple days to cash the check, and they were okay with that. And then I had to back out of one of the contracts due to some, errors in it, and I obviously didn't have the funds after that. And, that being said, the equipment was returned in perfect condition, and I understand my mistakes there. So with that, I would ask for probation and believe my counsels.
He confirmed that there was no intention to cause harm, took responsibility for his actions, and noted that all the vehicles had been returned in good condition. He asked for the opportunity to be placed on probation and expressed a desire to return to work to support his growing family, mentioning that he had a baby on the way.
This court has sentenced individuals on theft cases a number of times, and I recognize that this is not a violent offense, but I will share, Mr. Yantis, that oftentimes on property crimes, it still very much affects the victims and their livelihood and their ability to cover their financial obligations, and it's incredibly disruptive to their lives. And this court has sentenced individuals meeting the threshold for felony counts all the way to hundreds of thousands of dollars. And this court believes that while you received probation in the Bingham County matter, and I will note for the party's remembrance, as I compare the date of incidences, that the Bingham County matter was April the 13th of 23, okay? And the Bonneville County matter is charged on the dates between March the 28th and April 1st, okay? And so that, in this court's mind, is relevant in the sense of what was happening in both counties at the same time. You just simply appeared in front of Judge Simpson before you did this court. This court is going to retain jurisdiction on your matter with an underlying sentence of 2.5 years fixed with 3.5 years indeterminate for a unified sentence of 6 years. The court will impose a $1,000 fine, and court costs in the Victims Relief Fund are standard. We will permit the state to submit restitution on this count within 30 days. Now, practically speaking, what this means is that I doubt that you will be transported to begin your retained jurisdiction until these other matters are resolved.
Despite the court's acknowledgement of these mitigating factors, Judge Dane Watkins Jr. ultimately sentenced Paul Yantis to a minimum of 2.5 years and a maximum of 6 years in prison. However, the judge retained jurisdiction and placed him on a 1-year rider program, requiring treatment while incarcerated. Upon completion, the court will decide whether to place him on probation or have him serve the full sentence. Yantis was also ordered to pay restitution to the victims involved in the case. On April 20th, 2024, a tragic crash occurred at the Swan Boat Club in Newport, Michigan during a young girl's birthday party. Marcella Chidester, 67, drove her Ford Edge SUV directly into the building, killing 2 siblings, Alana and her brother Zane Phillips, and injuring over a dozen other men, women, and boys and girls attending the event. Moments before the crash, home surveillance footage captured Chidester reversing out of her driveway and colliding with a neighbor's truck, indicating signs of impairment before she even left her neighborhood. When first responders arrived, they encountered a highly distressing scene. Deputy Stephen Schmidt of the Monroe County Sheriff's Office later testified that it was one of the most chaotic and emotional scenes he had ever witnessed. Upon approaching Chidester, he noted signs of possible impairment, including the smell of alcohol and visibly red, watery eyes. Though Chidester stated she suffered from neuropathy, she was still asked to perform modified sobriety tests, which she did not pass. She was then taken into custody and transported to the hospital, where a blood test revealed a blood alcohol level of 0.18, more than double the legal limit. Inside her SUV, officers found a small bottle of Chardonnay in the center console. Later, investigators searching her residence discovered empty wine and whiskey containers. Additional home surveillance footage reviewed by Detective Sergeant Jeff Hooper showed Chidester leaving her house, making contact with a parked vehicle, and then continuing toward the Swan Boat Club in the moments before the crash. In court, Chidester's defense claimed that a medical condition, not alcohol impairment, caused the crash. However, the prosecution presented strong evidence showing otherwise, including her high BAC home surveillance footage, eyewitness accounts, and critical EDR data.
As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Ro Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career, and she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond, that typically a blood sample would be dropped in the mail. This one was hand-delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified to the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed, so what can you folks do? What other evidence can you look at to support the experts' evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
To 10, 0 being like you're stone cold sober, you can drive perfectly. 10 being you're passed out drunk. Where do you think you're at right now? 7. A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin.
When did you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh.
And how do we know she had more than the one drink at Vernus? It's well established in the evidence, and I don't think either side disputes, she left Vernus at the latest at 12:15. The crash was at 3:01. But remember what she told Sergeant Bomia.
A little bit, yes.
When's the last time you had something to drink?
Probably half an hour ago.
Half an hour ago? What did you drink?
Wine.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Vernus. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Vernus wasn't her first or her last drink of the day.
Deputy Nicholas Burkhart from the Monroe County Sheriff's Traffic Services Division arrived after handling another case and began documenting the crash site through photographs. He also supervised the removal of the SUV to a secure indoor storage facility. 2 days later, he returned to retrieve the vehicle's Event Data Recorder, EDR, which stores crash-related data.
That's correct. I followed the vehicle to assure that it was placed in a secured inside storage facility, and then I returned on the 22nd to continue the investigation.
Okay. Other than taking photos, did you do anything else as it related to the vehicle?
Yes, I did.
What did you do?
I stood by while an employee of Jim's Towing removed the vehicle's event data recorder so I could take it back to the sheriff's office as part of the investigation.
What is an event data recorder?
An event data recorder is a module in most motor vehicles that will monitor various diagnostic points of a vehicle. It kind of constantly overwrites itself until an event occurs that causes the data points to be locked in.
Have you received any training with regard to event data recorders?
I did. In August of 2021, I successfully completed the Bosch CDR technician training that was provided by the Institute of Police Technology and Management at the University of North Florida.
So Bosch CDR training, what is that for the jury's understanding?
So the Bosch CDR is a computer program that allows us to image the data that's been locked in a vehicle's event data recorder and use that image to produce a report that can be analyzed.
Okay. So you took custody of the physical device, the physical unit, from the tow truck driver?
That's correct.
And once you took custody of it, what did you do?
Once I had possession of the EDR module, I returned to the sheriff's office and utilized the Bosch CDR software to obtain an image of the data that was stored on the EDR module itself.
Have you done this sort of thing before?
I have.
About how many times?
I would estimate a few dozen times.
Okay. And this extracts information from the unit to create a report, you said?
Yes, it takes an image of all of the saved information on the module and generates a report for it.
Okay. Deputy, I'm going to show you what's been marked People's 14. It's a stipulated exhibit, but to just show it to you to identify it. Could you tell us what that is?
Yes, I can. So this is a copy of the Bosch CDR report that was generated as a result of the image that I took of the data that was on the EDR module.
Okay, and that's the EDR module. Well, let's back up. I never asked you this. What kind of vehicle is this?
It's a Ford Edge.
Okay. Do you know what model year?
I do not know off the top of my head.
Okay. So at this point, Judge, people would move for admission of People's 14 as a stipulated exhibit.
I believe it was stipulated already. People's 14 is admitted.
Thank you, Judge. So, despite how many of these you've downloaded, are you qualified to discuss the contents of the report?
I am not.
Why not?
There is a separate course, which is an EDR analysis course, and I have not attended that yet.
Okay. So you're qualified to procure the image, but not to analyze it and discuss it?
Yes. So my qualification is for the use of the CDR imaging tool that allows us to obtain the image from the stored data.
Lieutenant Brian Quinn, head of the department's Traffic Services Unit, analyzed the EDR and found that in the 5 seconds before impact, Chittister's vehicle accelerated from 29.4 miles per hour to 44.3 miles per hour, with the accelerator pressed at 96%. No braking was recorded at the time of the crash, suggesting deliberate acceleration and no attempt to stop.
All right, Ms. Chidester, you've been found guilty by a jury of your peers, 2 counts of second-degree murder, 2 counts of operating under the influence and causing death, and 5 counts of operating under the influence causing serious bodily injury. You are to be sentenced in these matters on May 15th at 3 p.m. That will be in this courtroom with Judge Nichols' permission. You are remanded to the Monroe County Jail pending sentencing. We are adjourned.
After 4 days of testimony and fewer than 2 hours of jury deliberation, Marcella Chidester was found guilty on all charges, including 2 counts of second-degree murder and multiple counts of operating while intoxicated, causing death and serious injury. She now faces a possible life sentence with a sentencing date yet to be set. In May 2022, a devastating crash at Cedar Valley Stables in Eagle Mountain, Utah, claimed the lives of 2 boys, Hunter Jackson and Odin Ratliff. The boys had been playing in a horse corral when a vehicle driven by 28-year-old Kent Cody Barlow sped off the road and slammed into the enclosure. Witnesses reported that Barlow was traveling close to 100 miles per hour and failed to stop at a nearby sign before losing control. A toxicology report later confirmed he had methamphetamines in his system at the time. Barlow was arrested and charged with 2 counts of first-degree murder, along with drug possession and other related charges. As legal proceedings unfolded, the case encountered repeated delays due to pretrial motions and complications. In July 2024, Barlow's attorney, Utah County Public Defender Ben Aldana, requested a trial postponement. He cited his father's terminal illness and the need for time away from work. Although prosecutors did not object, Judge Robert Lund denied the request, arguing the motion lacked sufficient supporting evidence. Shortly after his father's passing on July 23rd, Aldana filed a motion to withdraw from the case entirely. He stated he was no longer mentally capable of continuing as defense counsel. Judge Lund denied this request as well, while expressing sympathy for Aldana's personal hardships. The judge maintained that the case needed to proceed and noted Aldana's record of strong legal performance.
Because of everything I've just said, all the work that you've done in front of me, you developed a reservoir of trust with the court, and that's really important as a lawyer. And that reservoir of trust impacted rulings that I made in this case. And I've described those rulings multiple times now as being unprecedented. You were concerned, in fact, alleged that the state had been withholding discovery, and you asked to review all of the state's internal email communications. That's an extreme position. I think I mentioned to the parties that in the entire 28-year prosecutorial career that I had, only one time did ever any judge require any internal work product communications of a prosecutor that I'm aware of be turned over, and it was in a very limited scope. So this was a really significant issue. But what I did was I agreed to do an in-camera review of it, and to his credit, Mr. McBride has never criticized that ruling, but I'm sure he took umbrage at the court doing that. But I did it because I trusted that if Ben Aldana was raising this issue, I should probably look into it. The other thing is the decorum order that we talked about today. That's another extreme order. Like, I'm unaware of any court that's ever entered an order that's that broad. And, the counsel for the television station, was here today and was very concerned about their rights. But I did that because I credited the concerns that you raised about the defendant receiving a fair trial. And I agreed with you. I want to make sure, and even though you may disagree with it, I have made every ruling in this case because I think it was the right thing to do. I've tried to understand the law and correctly apply it here and try to be fair to both parties. And so that's the way that I see the general context of this of this situation, and so I want to make sure you were aware of my perspective about the quality of representation, and I would have guessed that you would think that, because you'll remember that after the case against that lawyer was dismissed, you and I had a conversation where I specifically complimented you on the quality of your work, and you and I had a discussion about what amount of money that lawyer would have to pay a private lawyer to do the work that you did in that case. Do you remember that?
Yes, Your Honor, I do.
Anyway, the context in which this happens is that this car accident happened and these two children were, and we've been trying now for over 2 years to get all the discovery, to get everything litigated, to get this case fairly tried in a timely way. And that's what I'm trying to do. Okay, so I want the parties to understand that that's what I'm trying to do, is just get this case over this finish line in a timely way. And I've tried to identify all the many competing interests that are involved here. And your circumstance, Mr. Allen, is one of those competing interests. So anyway, I appreciate everybody's hard work today. We're making progress to get this case to trial.
In response, Aldana petitioned the Utah Supreme Court, challenging Judge Lund's refusal to allow his withdrawal. On September 13th, the state's high court sided with Aldana, ruling that Judge Lund had overstepped his discretion. Aldana was officially released from the case. This decision caused another delay, and the trial was postponed once again. A new judge was expected to be assigned, further extending the timeline. The continued setbacks have deeply frustrated the victims' families, who have been waiting more than 2 years for resolution. The situation has also cast a spotlight on systemic issues within the Utah County Public Defender Association. Critics have pointed to attorney caseloads and limited resources as contributing factors in the drawn-out process. As of late 2024, a judge had declined to dismiss the murder charges against Barlow, and the trial was tentatively rescheduled for April 2025. With pretrial motions ongoing, the court is working to balance legal obligations with the need for closure in one of Utah's most heartbreaking recent cases. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.